Welcome to our myth-busting series. Today, let's dive into a topic that stirs up a lot of conversation: the authority of Waqf boards under Section 40 of the Waqf Act 1995. Section 40 is one of the most debated and controversial parts of the Act.
To move for leave to introduce the Waqf Amendment Bill 2024.
Some groups, particularly right-wing factions, argue that this section gives Waqf boards the unchecked power to declare almost any property in India as Waqf land.
Once a Waqf, always a Waqf. ये country within country है.
Yes. मथुरा श्री कृष्ण जन्मभूमि के केस में क्या हो रहा है, भोजशाला में क्या हो रहा है, ये वही पैटर्न ताजमहल में भी अडॉप्ट किया गया है.
संविधान में वक्फ कानून का कोई स्थान ही नहीं है.
But is that really the case? Let's dissect this claim with evidence and context. Let's start by talking about Section 40 of the Waqf Act. This section gives Waqf boards the authority to determine if a property qualifies as Waqf. Critics argue that this provision allows for arbitrary claims. But here's what's really important to understand. First, the board can't just declare any property as Waqf without a proper inquiry.
वक्फ बोर्ड के ऑलमोस्ट सारे मेंबर सरकार नॉमिनेट करती है. अगर वक्फ बोर्ड ने किसी प्रॉपर्टी को कहा कि ये वक्फ प्रॉपर्टी है, तो पहली चीज तो उसके कहने से नहीं होगा, सर्वे होगा. सर्वे कमिश्नर जो होगा वो सरकार का पब्लिक सर्वेंट है. उसके बाद उसकी रिकमेंडेशन वक्फ बोर्ड को जाएगी, जो स्टेटरी बॉडी है, ऑल नॉमिनेटेड बाय गवर्नमेंट एक्सेप्ट 1 और 2 मुतवल्ली जो इलेक्ट होके आ जाएंगे. फिर वो सरकार को रिकमेंड करेंगे, सरकार के ऑफिशियल गजेट में पब्लिश होके ही कोई प्रॉपर्टी वक्फ बन सकती है.
If they have evidence to believe a property is Waqf, the board is required to conduct a thorough investigation through the survey commissioner. This includes gathering relevant documents, hearing from stakeholders, and reviewing the property's historical and legal records. And this whole process is open to scrutiny, as sections 5 and 6 of the Act make it clear. On top of that, almost all members of Waqf boards and survey commissioner are appointed by the government, giving the government a level of control. Second, the decisions made by the Waqf board are not final. Under Section 83 of the Act, there is a tribunal, meaning a special court, where these decisions can be challenged. So if someone believes the decision is unfair, they have a way to contest it. And third, Waqf boards must follow principles of natural justice. This means they can't make decisions without giving the affected parties a chance to be heard and represent themselves. So, while Section 40 does empower Waqf boards to determine whether a property is Waqf, it is also complemented by Sections 4, 5, 6 and 83, which provide essential checks and balances to promote fairness and transparency. Now let's look at whether similar powers are given to Hindu endowment boards. Unlike the Waqf system, which is governed by the Central Waqf Act 1995, there's no uniform central law for Hindu endowments.
Hindu endowment boards are recognized even by usage and custom. और एक new convert है, does he has to wait for 5 years to give his property to Waqf? Isn't that violation of right to freedom of religion? No such provision exists for Hindu endowment or Sikh Gurdwara Prabandhak Committee. Non-Muslims can become member of CWC SWB, but he cannot dedicate Waqf.
Each state has its own laws, and Hindu endowment boards are responsible for determining the status of religious endowment properties. This means the process for determining whether a property qualifies as a religious endowment is generally less formal compared to the Waqf Act. Looking at all the evidence we've covered, it is clear that the Muslim Waqf boards do not have arbitrary power to decide whether a property is Waqf. They can't just declare any property as Waqf without going through a formal process. And here's a critical point. In a country where Muslims face systemic exclusion and lack social and political power,
poor Muslim families are victims of far-right Hindu groups, bent upon pushing India's largest minority into second-class citizen status.
Also found evidence that they used excessive force against Muslims. So a Muslim man died after he was beaten by the policemen, by a group of policemen.
क्या बेचते हो आप? Thanks, Shed.
अगर उसके बाद किसी दुकानदार ने किसी मुसलमान को अपनी दुकान पे रखा, उसके दुकान के बाहर उसके बहिष्कार का मारने को तैयार है, जेल में जाने को तैयार है। मेरे को ये बात मिल गई है, हिंदू को भी अपनी आत्मरक्षा के लिए अस्त्र उठाना पड़ेगा और कार्रवाई करनी पड़ेगी।
Over here, 84 communal riots, Nelly massacre, Gujarat, everyone who presided over this program, they have made their political palaces on my grave.
Do you really think Muslims would have unchecked power to decide if a property is waqf? If that were the case, lands like Babri Masjid and others would have stayed with the Muslim community.
एक वो मस्जिद जिसमें 400 साल नमाज भी हुई, वो भी वक्फ बाय यूजर साबित तो नहीं हो पाई.
Now, the omission of Section 40 is a move that many believe is driven by political interests, potentially pushing the Muslim community further to the margins. In our next myth-busting video, we'll dive deeper into the implications of this omission and why it poses significant challenges. So stay tuned and subscribe to Nous.